President Trump's legacy could hinge on how things play out with Iran, but the way he's remaking the federal bench could have effects that last even longer as judges get lifetime appointments. This chart tells the story. Donald Trump has appointed more people to the federal bench than any of his 5 predecessors had at this point. We can thank Mitch McConnell for that. The Senate Majority Leader refused to confirm many of President Obama's late appointments, so Trump inherited a slew of vacant seats to fill, and he's filled them with conservatives right out of the Heritage Foundation's Hall of Fame. I'm going to quote from the Washington Post, as it does a good job describing the implications of this. Trump nominees make up 1 in 4 U.S. Circuit Court judges. Trump's appointments have flipped 3 circuit courts to majority GOP-appointed judges. The president has also selected younger conservatives for these lifetime appointments, ensuring his impact is felt for many years. The 13 circuit courts are the second most powerful in the nation, serving as the last stop for appeals on the lower court rulings, unless the case is taken up by the Supreme Court. Trump's mark on the judiciary is already having far-reaching effects on legislation and liberal priorities. Just last week, the Fifth Circuit struck down a core provision of the Affordable Care Act. One of the 2 appellate judges who ruled against the landmark law was a Trump appointee. Let's bring in our next guest, Dahlia Lithwick. She writes about the courts and the law for Slate. She also hosts the podcast Amicus. Everybody focuses on the Supreme Court. It gets all the attention. We know that Trump and McConnell have focused on reshaping the appellate courts. We gave a brief overview of what those courts are and why they're so important, but what else can you give us to describe the significance of those courts and why packing them with young conservative judges has become such a priority for the GOP?
I guess the most useful way to think about it, Andrew, is to just realize that the U.S. Supreme Court hears between 60 and 70 cases a year. That means that thousands and thousands and thousands of cases are just resolved finally and definitively at the U.S. Circuit Court level, where the courts of appeals are. So while we hear about these big ticket cases, and this term has a lot of them about guns, about abortion, about LGBTQ rights, the fact of the matter is the vast bulk of cases will be decided once and for all and forever in the lower circuit courts. And no less of a person than Sonia Sotomayor famously said, the circuit courts are where policy gets made. So I think you're right. We focus exclusively at the Supreme Court at our peril because we've already seen, as you said, the numbers, 3 federal circuit courts of appeals have already flipped, have become majority Republican just in 3 short years. That is going to continue. And as you said, these judges sit for life. Some of them are 40 and 50 years old. So long after Donald Trump is gone and long after Democrats could theoretically start to reinstate environmental or reproductive rights or LGBTQ protections, the courts, the federal courts, will be striking them down.
Will this new court balance dictate or change which cases are sort of brought up the ladder towards the Supreme Court? Will it also alter what bills actually get passed into law?
Yeah, it's a great question. And we're already seeing that litigation strategy is changing. And so, for instance, there was a landmark case involving gun rights that went up to the U.S. Supreme Court this term. It was a case that would have been the first time in 10 years that the Supreme Court stepped into the Second Amendment controversy again and made some determinations about the contours of what the right to bear arms means. And we saw immediately that the state of New York, out of just fear that the court would expand gun rights and limit the possibilities for state to effectuate gun controls, pulled it back and said, oh, no, this law is not the law anymore. Don't pay any attention to us. So you're seeing in a lot of quarters, whether it's reproductive rights, whether it's environmental cases, whether it's voting rights cases, that litigants are terrified of this Supreme Court. And so they're actually hedging their litigation strategy to conform to that. But I think it's also the case, as you say, that the kinds of cases that are being rushed to the Supreme Court, the kinds of cases that would eviscerate gun control, that would eviscerate regulation of the environment, the kinds of cases that would really, really press to eliminate Roe v. Wade, are being really, really pushed quickly at the court. I think there's a sense, and we really see it in the abortion context, that litigants say, hey, the wind is at our back, this is our moment, and we're going to leapfrog and get these cases to the justices now while we have the court. So it is informing strategies on both sides of the equation.
As we mentioned in the setup, this actually predates Trump. He's just the guy who filled the openings that Mitch McConnell helped create. Was this a long-term plan from McConnell, and was it solely McConnell's? The Heritage Foundation has been so involved in this process with Trump's judicial appointments. Have they been planning a strategy like this for a long time?
Yeah, this is not something that the advent of which comes with Donald Trump. This is something we really saw in the Obama era take root, and that was a sort of all out obstruction strategy that started with Mitch McConnell when he gained control of the Senate and started using a whole bunch of different Senate tricks. You can talk about blue slips, which is a veto of home state senators. You can talk about the length of time that you had to vet nominees. The American Bar Association had a major role in vetting nominees. All of those strategies used to be in effect. And what we saw when Republicans took over control of the Senate, and this really was a singular vision of Mitch McConnell, all but stopping the pushing forward of Obama nominees. Both McConnell and Donald Trump really like to brag that Trump took office with 142 federal seats open, and that was because of obstruction, whether it was blue slips or whether it was other processes, filibusters. That what they did was essentially hold open tens and tens and tens of seats, some of which were open, by the way, for years. And so the minute Donald Trump stepped into office, the machinery was in place to say, fine, now we have the nominees we like, now we have the Senate. And I think you're quite right to say that this is a Senate that has done almost nothing in terms of a legislative agenda. We've got congressional bills that are piled up that Mitch McConnell will not move forward. It is a juggernaut, however, on this one front, which is confirming Trump judges. The week of Christmas alone, a whole pile of judges were confirmed when nobody was looking.
Dahlia, if the Democrats win the Senate and or the White House, is there anything they can do about this? I mean, I wouldn't think impeaching these judges would be feasible. What about expanding the number of judges or even expanding the number of courts?
It's a great question, and there are a lot of grassroots organizations right now that are doing work trying to think about court packing or term limits or jurisdiction stripping, saying maybe judges just don't get to hear certain types of cases. That is all in the works on the Dem side, but it's worth saying none of the nominees for president under the Democratic banner are interested in talking about much of any of this. I think Pete Buttigieg has sort of made feints at saying maybe we should think about this. But I think that the sense is that it is a radical notion. It's not going to garner votes, and it's too soon to talk about it. And so we're in this very, very strange impasse where it's clear that, you know, 1/4 of the circuit court judges, 1/5 of the district court judges are now Trump judges, and nobody running for office wants to talk about what to do about it.
Dahlia, I want to hit you with two other court-related topics. First of all, this week, nearly 200 members of Congress, almost all of them Republicans, signed a letter asking the Supreme Court to overturn Roe versus Wade, the ruling that makes abortion legal in the U.S. That they would support overturning Roe isn't surprising. What does that tell you, though, about the GOP's focus on this issue? And with 5 conservatives now on the Supreme Court, how worried are you, how worried should we be that Roe may soon fall?
This kind of dovetails with what you asked me initially, Andrew, about whether litigation strategy is changing because the courts are changing. And there are essentially 2 paths to doing away with Roe. One is the one we've seen for the last few decades. That's these so-called trap laws, right? Laws that target abortion clinics and that say that all the things you have to do in order to stay in practice as an abortion clinic will have the effect of putting you out of business. That's what we saw in Texas. That was the law in Texas. That was the admitting privileges law and the rejiggering abortion clinics law. Those laws generally have been sort of having a creeping effect on closing clinics in the states. But since Brett Kavanaugh came onto the court, and I would say almost to the day Brett Kavanaugh came onto the court, there's been this second movement, which is no longer talking in terms of we want to protect maternal health, we want moms to make good choices, we want to show them ultrasounds and have waiting periods so that they can make better choices. Now we're seeing this kind of thing that we're seeing in Georgia, in Alabama, the kinds of laws we're seeing in Ohio that are very punitive towards mothers. There's no longer a kind of pretext that we want to do away with women making bad choices. Now we just want to put women and doctors in jail if they get involved in abortion in any context. And it's that second train of cases that you're seeing run through the brief that was filed with the court. That's the line of cases that says we're not going to kind of chip away at Roe the way we've been doing in the states for the last few decades. We're going to ask the court to simply overturn Roe, the 1973 case that was the precedent, and also Casey, which was the 1992 case that reaffirmed Roe. This is a kind of attempt to say we don't want to do this in small incremental pieces. We're going to go big or go home. And it's of a piece with these state statutes that are being passed that simply ignore the fact that Roe is the law and say we're going to have a ban at 6 weeks or 8 weeks, and we're going to put women in jail if they get abortions after that. So I see this secondary track as being one that is very, very worrisome because it means that kind of the pretext is stripped away. We're now talking about not just doing away with Roe and Casey, but actually punishing women and doctors who see fit to have an abortion. It is a very, very draconian and I think radical strategy. A little bit it does put to the lie the last few decades worth of efforts to say we just wanted moms to make better choices.
Finally, Dahlia, John Roberts, the Chief Justice, will preside over a Senate impeachment trial if we ever have one, with everybody trying to figure out what kind of role he'll have, how active he would be. He also put out an end-of-the-year message looking to promote confidence and trust in the court. He even praised the elementary school tutoring efforts of the Chief Judge of D.C. Circuit Court, a man named Merrick Garland, who once had been nominated to be on the High Court. As everybody's looking for signs of what Roberts will do, is there any reason to think that he'll do anything but follow the Rehnquist example from 1999 and involve himself as little as possible in the trial? If Democrats are looking for Roberts to save the day on witnesses or anything else, are they just fooling themselves?
Isn't it amazing that the most interesting man in America today is this kind of very, very quiet, soft-spoken lawyer from Indiana? Nobody thought John Roberts would be the most fascinating constitutional figure, but I think you're completely right, given the impasse that we're at between Mitch McConnell in the Senate and Nancy Pelosi in the House, and the White House making extreme claims about privilege and about immunity. It is, in some sense, going to all come down to John Roberts. And I think you're right. We can look at and try to read the tea leaves of his end of the year, State of the Judiciary statement. It was 7 pages of very, very, I think, carefully lawyered language about civility and judicial neutrality. I can't read too much into it other than to say it seems that he doesn't have a lot of patience for people trashing the judicial branch, but whether that means he wants to insert the judicial branch in the person of his own self directly into the middle of impeachment trial proceedings is a really hard question. Chief Justice Rehnquist, for whom Roberts clerked, famously said of the Clinton impeachment hearings, "I did nothing and I did it well." And I think that John Roberts would probably very much like to say the same thing at the end of a Senate trial. I do think there are going to be material questions about subpoenas and witnesses that he might have to rule on. And in some sense, I think this is a tension between the John Roberts who wants to kind of disappear back into the hedges of history and the John Roberts who's a little bit aware that he might be the last adult in the room.
Dahlia Lithwick writes about all things related to the courts for Slate. She is also the host of the Amicus podcast. Dahlia, Happy New Year. As always, thank you.
Thanks for having me.
And up next year on RFL, a look at some news you might have missed while the country was focused on Iran and impeachment.